Hi, I'm attorney Renee Osipov with Chelle Law, and we assist physician assistants with employment contract issues. Today I'm answering the question, can a physician assistant break their contract? The answer is yes, they can. However, if breaking their contract means that they're breaching it, they're not adhering to the terms that they agreed upon, they may have some legal or financial consequences that you will definitely want to consider before making that decision. So before you break the contract, there are normally lots of different ways that you can be let out of your contract. So you always want to go to your employment agreement and read it very carefully. There's normally many clauses on termination. So your employer can terminate your agreement for a cause. If you have violated some policies, you've lost your license to practice, you're convicted of a crime, there's normally a enumerated list there. And so if any of that happens, then your employer will actually terminate the agreement. Another way you can be let out of your employment agreement is a without cause termination. So most employment contracts, and you want to read yours carefully, will have a clause in there that says you may terminate your employment without cause. So it can be for any reason or no reason at all upon giving a certain amount of notice. So that range can be anywhere from 60 to 90 days. Occasionally, if you're in a rural area or a high need area, sometimes it can go up to 120 days. So if you want out of your contract, you need to give a written notice and it needs to be given properly. Again, this can be a little unique to each situation. So you want to look at that employment agreement and it will state how you need to give proper notice. It's usually always in writing. It can be hand delivered to certain personnel. Sometimes it has to go through certified mail. Other times you're able to email it to certain personnel as well. So just make sure you give your notice properly and you give your notice with the appropriate time. So like we talked about, it's normally 60 to 90 days. And then you can be let out of your agreement. And that's the best way to do it. However, even if you do it this way, there still might be some financial consequences. If you received any type of sign-on bonus or relocation bonus or reimbursement, those type of bonuses, when you're given a lump sum up front, whenever you're starting your employment, normally have some sort of requirement that you must complete a certain period of time with the company. This is normally anywhere from 1 to 3 years. And if you terminate your employment for any reason within that time, you may have to pay back that entire bonus, or you may have to pay back the bonus at a prorated amount, which kind of means however many months you've been there, a portion of that amount is forgiven. You always want to be careful that you're not just breaching the contract, again, because you still, even if you breach the agreement, there may be something in your contract called liquidated damages or something about damages, meaning if you break this agreement, you don't give proper notice, you will have to pay your employer tens of thousands of dollars. So this is something that you always want to look out for. I do see this in about 50% of all the contracts that I review, so you want to be really careful. If you have any further questions, breaking a contract is kind of serious, so I always recommend consulting an attorney. That's something we do here at our firm to make sure, that you are terminating your contract properly. And if you're not, do you know the consequences, for litigation, arbitration, financial penalties, anything like that. So it's good. If you want more information, you can check out our website, Chelle Law, CHELLE law.com. Our contact information is on there as well. Thanks.